Good day, my name is Rebecca. Today I am going to talk about the influence of Monist and Dualist legal system on international climate agreements, specifically in navigating compliance disparities. In this video, we are going to look at the overview of legal principles, the issues or challenges of Monist and Dualist legal systems, as well as the recommendations to improve consistency across various legal systems. The complexities of global climate agreements, particularly in the context of varying legal systems, underscore the challenges nations face in meeting their emission reduction targets. Every state operates under its own domestic law, which governs relationship between individuals or between individuals and administrators within the country. On the other hand, all states are bound by international treaties, collectively known as international law, which aims to regulate interactions and manage conflicts between states. To navigate the relationship between domestic and international law, states typically employ two main theoretical frameworks such as monism and dualism. In this video, we will look at how the distinction between monist and dualist legal system significantly influences how countries incorporate international commitments, particularly climate agreements, into their domestic laws, leading to disparities in compliance among countries. The monist versus dualist theory of international law has long been debated as two contrasting approaches to the relationship between international and domestic law. While these theories may have limited explanatory value in practice, they serve as valuable analytical tools for understanding the interplay between the two legal spheres. In theoretical terms, the application of international law in national legal system is often explained in terms of the doctrines of incorporation and transformation. It is often said that the doctrines of incorporation and transformation correspond with monism and dualism respectively. Under monism, the doctrine of incorporation is applied, where international law is regarded as automatically incorporated into municipal law. In other words, international law is ipso facto part of municipal law and may be applied as such by the municipal courts. Dualism, on the other hand, applies the doctrine of transformation, which indicates that international law is not ipso facto part of municipal law. A rule of international law will become part of municipal law only after the transformation of it into municipal law by means of a statute or an act of parliament. Let's see the overview of the monist and dualist system. Monism posits that international law is incorporated into and superior to domestic law, creating a unified legal system where international law prevails over domestic laws. This principle allows individuals to invoke international norms directly in national courts, enabling challenges to domestic laws that may violate international obligations. Monist theories can be categorized into two distinct perspectives. The one is the ethical perspective and the other one is the formalistic perspective. Scholars like Sir H. Lauterpacht emphasize the moral imperatives of human rights within international law, viewing individuals as the ultimate subject of both international and domestic law. Lauterpacht argues for the supremacy of international norms to ensure the protection of human rights, reflecting a commitment to universal justice over state sovereignty. In contrast, Hans Kelsen represents a formalistic approach focusing on the hierarchical structure of legal norms. Kelsen contends that international law should be superior to domestic law based on logical consistency within a unified legal system, asserting that both international and municipal laws share the same subject matter and that international law supremacy is essential for maintaining a coherent legal order. The practical implications of monism are significant as it allows for the direct application of international law in national legal system. For instance, when a country ratifies a human rights treaty, individuals can invoke that treaty in their national courts without needing additional legislative action. This direct applicability not only enhances the enforcement of international norms but also reduces the risk of states violating their international commitments. Ultimately, monism fosters accountability on the global stage by reinforcing the idea that states are bound by their obligations under international law, thereby promoting a more integrated legal system that prioritizes human rights and ethical standards. On the other hand, dualism argues for a clear separation between international and domestic law, with international law requiring domestic implementation to be binding at the national level. This means that in dualist system, international law does not automatically apply within a state. Instead, it must be incorporated into domestic legislation through specific acts of parliament or other legislative measures. Scholars like Triple emphasize that while both legal systems may address similar subject matters, they operate independently, with international law regulating the relationship between state and municipal law, governing the rights and obligations of individuals within those states. Consequently, for international law to have any legal effect domestically, it must be explicitly translated into national law. The dualist approach is fundamentally positivistic, stressing the supremacy of the state in legal matters. In this framework, if a state ratified an international treaty but fails to enact corresponding domestic legislation, the treaty does not create enforceable rights or obligations within that state. This necessitates a careful process of legislative incorporation where existing national laws may need to be modified or repealed to align with international obligations. Thus, dualist systems require continuous monitoring to ensure that new domestic laws do not conflict with previously ratified international treaties, reinforcing the state's authority over how and when international law is implemented within its jurisdiction. How the fundamental differences between monist and dualist legal system contribute to the challenges nations face in complying with multilateral environmental agreements, particularly regarding climate change. Firstly, let's look at the challenges monist systems encounters in harmonizing domestic legislation with international commitments. The first legal challenge will be legal alignment issues. Since international law is automatically incorporated into national law through the doctrine of incorporation upon ratification, the international obligations take precedence over conflicting domestic laws. This is affirmed by the International Court of Justice in its ruling in the applicability of the obligation to arbitrate case, which asserts that international law prevails over domestic law. This principle reinforces the idea that states must align their domestic legal framework with their international obligation to avoid conflicts and ensure compliance with global treaties. However, this can create a legal tension, particularly when national legislation contradicts international treaties that a state has ratified. For instance, in the United States, during the Bush administration from 2001 to 2009, there was a refusal to regulate climate change under existing environmental laws or to support the enactment of new climate change legislation, despite being a party to international treaties like the Paris Agreement. This inaction, coupled with the US role as a major emitter of greenhouse gases, intensified the search for alternative climate protection measures. This led courts to put pressure on the executive branch to address climate change, effectively prioritizing international treaties over national legislation. This highlighted the difficulties in harmonizing domestic laws with international commitments, especially when national interest or political consideration impede compliance. The second legal challenge will be constitutional conflicts. The legal foundation for prioritizing international obligations is articulated in Article 27 of Vienna Convention on the Law of Treaties of 1969, which states a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This rule emphasizes that a state cannot use its domestic laws as an excuse for not fulfilling its international obligations. This creates a situation where states must align their domestic legal frameworks with international obligations, leading to potential constitutional conflicts. Article 46 of the Vienna Convention further elaborates on this by indicating that a state may not claim that its consent to be bound by a treaty is invalid due to a violation of internal law unless that violation is manifest and pertains to a fundamental rule of internal law. The Alabama claims arbitration case exemplifies this issue, where the US objected to Britain allowing a Confederate ship to operate from its ports. The tribunal held that Britain's lack of legislation to prevent the ship's construction or departure could not be used as a defense. Consequently, Britain was held liable to pay damages for not preventing actions that violated its international obligations. This reinforcing the notion that states must fulfill their international obligations regardless of domestic legal constraints. The practical challenge will be inconsistency in judicial interpretation. Despite the automatic incorporation of international law, not all treaties are self-executing. Some require additional legislative action for full implementation. This can lead to inconsistencies in how courts interpret and enforce these treaties domestically. If judges misinterpret or inconsistently apply international law, it may result in breaches of international commitments, thereby undermining the effectiveness of the monist approach. In Crown v. Jonas, the House of Lords addressed the issue of whether individuals could claim a defense of necessity when charged with criminal damage under Section 3, Subsection 1 of Criminal Law Act 1967 for acts committed during a protest against UK's involvement in the Iraq War. The defendants argued that their actions were justified under international law, specifically citing the prohibition against uh, aggression as outlined in Article 51 of the Rome Statute of the International Criminal Court. However, Lord Bingham rejected the incorporation theory for all customary international law, asserting that not all international crimes automatically translate into domestic offences. He emphasized that while international law may inform domestic legal principles, it does not create rights or defenses under UK law unless explicitly incorporated through legislation. This ruling underscores a critical inconsistency within Monist systems, although international treaties are theoretically incorporated into domestic law in the UK. Their application can vary significantly depending on judicial interpretation. In contrast, in Tentex Trading Corporation versus Central Bank of Nigeria, Lord Denning adopted a more progressive stance by affirming that new international rules should be recognized by domestic courts even without explicit legislative incorporation, thereby allowing for greater flexibility in applying international norms such as state immunity. This divergence between cases highlights how varying judicial interpretation can lead to inconsistent application of international obligations, complicating compliance with those commitments and undermining the effectiveness of the Monist approach in addressing pressing global issues like climate change. Let's look at the challenges dualist system encounters in harmonizing domestic legislation with international commitments. The legal challenge will be delay and complexity in legislative processes. Dualist system require that international treaties be translated into national legislation before they can be enforced domestically. This necessity for translation can lead to significant delays and inconsistencies in compliance, especially regarding urgent issues like climate change. For instance, while a Monist state may quickly implement provisions of the Paris Agreement through its existing legal framework, a dualist state may face substantial delays as it navigates its legislative process. In many climate trials, international law is rarely applied directly as a source of positive law, either due to the dualist nature of the legal system or because the obligations in question are not viewed as self-executing and therefore cannot be directly invoked by individuals. However, the Paris Agreement has been successfully used in various cases to interpret domestic rules, either alone or in combination with other international obligations. For example, in Malaysia, the implementation of international treaties has to a dualistic approach, necessitating both executive ratification and legislative enactment for domestic application. While the government can sign and ratify treaties, they do not automatically become part of domestic law. Instead, they must be transformed into legislation to be enforceable. This practice is based on the doctrine of transformation, which stipulates that treaties affecting individuals' rights or necessitating changes to existing laws requires parliamentary approval. Consequently, this legislative requirement can lead to delays and complications, particularly when political opposition arises. For instance, the Malaysia government faced challenges in ratifying human rights treaties like the International Convention on the Elimination of All Forms of Racial Discrimination and the Rome Statute of the International Criminal Court due to political resistance. Overall, these examples demonstrate how the dualist approach complicates timely compliance with international obligations by requiring legislative action, which can lead to delays and inconsistencies in treaty implementation across jurisdiction. Consequently, urgent global issues like climate change may face inadequate domestic responses due to this systematic complexity. The practical challenge will be fragmentation of legal frameworks. Fragmentation refers to the development of multiple legal regimes that operate independently, often resulting in conflicting norms and principles. This phenomenon can arise from the emergence of specialized areas of law such as environmental law, trade law, and human rights law, which respond to specific societal needs but may not align with existing international obligations. The International Law Commission has emphasized that while fragmentation reflects the diversification of international law, it also possesses significant risk of incoherence and conflict among legal norms. The existence of overlapping legal regimes complicates the legal landscape for practitioners and judges who must navigate various sources of law that may conflict with one another, making it difficult to determine the applicable legal framework for specific cases. This complexity can hinder effective legal reasoning and decision making. The recent request for an advisory opinion from the ICJ further illustrates these challenges, as it draws attention to multiple intersecting areas of law such as human rights, environmental law, and international treaties that often lead to conflicting obligations. This fragmentation can create scenarios where states may comply with their climate agreements under one legal regime while stimulously violating obligations under another, such as the duty to prevent significant harm to the climate system. The potential for regime collisions becomes evident particularly in contexts like the Paris Agreement's emphasis on common but differentiated responsibilities, which operates differently within maritime law that does not differentiate obligations based on the state capabilities. If the ICJ issues an advisory opinion, it could serve as a unifying force by clarifying states' obligations under international law regarding climate change while acknowledging the fragmentation present in existing legal frameworks. The practical challenge will be fragmentation of legal frameworks. Fragmentation refers to the development of multiple legal regimes that operate independently, often resulting in conflicting norms and principles. This phenomenon can arise from the emergence of specialized areas of law such as environmental law, trade law, and human rights law, which respond to specific societal needs but may not align with existing international obligations. The International Law Commission has emphasized that while fragmentation reflects the diversification of international law, it also possesses significant risk of incoherence and conflict among legal norms. The existence of overlapping legal regimes complicates the legal landscape for practitioners and judges who must navigate various sources of law that may conflict with one another, making it difficult to determine the applicable legal framework for specific cases. This complexity can hinder effective legal reasoning and decision making. The recent request for an advisory opinion from the ICJ further illustrates these challenges as it draws attention to multiple intersecting areas of law such as human rights, environmental law, and international treaties that often lead to conflicting obligations. This fragmentation can create scenarios where states may comply with their climate agreements under one legal regime while stimulously violating obligations under another, such as the duty to prevent significant harm to the climate system. The potential for regime collisions becomes evident particularly in contexts like the Paris Agreement's emphasis on common but differentiated responsibilities, which operates differently within maritime law that does not differentiate obligations based on the state capabilities. If the ICJ issues an advisory opinion, it could serve as a unifying force by clarifying states' obligations under international law regarding climate change while acknowledging the fragmentation present in existing legal frameworks. Let's see what are the recommendations to improve consistent adherence across the various legal systems. Firstly, legislative reforms for alignment. There are two ways to do it. One is by encouraging state compliance, where the states should be motivated to align their national laws with international obligations through legislative reforms. This can involve establishing clearer guidelines for integrating international treaties into domestic law, thereby reducing conflicts and enhancing compliance. By adopting a systematic approach to harmonization, states can minimize discrepancies between domestic and international legal frameworks, which is crucial for effective treaty implementation. Another way will be by the simplification of legal frameworks. Regularly review and simplify national legislation to enhance clarity and usability. This includes eliminating redundancies and developing general application acts which can reduce the volume of legislation while increasing consistency across legal systems. Such simplification efforts will help ensure that laws are no more complex than necessary to achieve their policy goals, facilitating better adherence to international commitments. Another recommendation is utilizing existing legal frameworks such as Vienna Convention on the Law of Treaties. Firstly, the Vienna Convention serves as a foundational framework for resolving conflicts between various legal regimes. States should implement established techniques from the Vienna Convention to effectively manage normative conflicts, ensuring that international obligations take precedence in domestic law. This approach involves employing mechanisms for treaty interpretation and conflict resolution that foster coherence between international commitments and national legislation. Secondly, utilizing the techniques outlined in the Vienna Convention allows states to navigate the complexities associated with overlapping legal obligations. This method not only clarifies how to address potential conflicts but also strengthens the adherence to international commitments. By prioritizing international obligation and employing structured conflict resolution strategies, states can achieve greater consistencies in their compliance efforts, ultimately leading to more effective governance in areas such as climate change and environmental protection. Last but not least, environmental consideration in jurisdiction. Firstly, mandate that all relevant cases incorporate environmental impact assessment as part of the legal proceedings. This requirement ensures that environmental consequences are considered in judicial decision across various types of cases, not just those explicitly related to environmental law. By integrating EIAs into the legal process, courts can better evaluate the potential impacts of their decisions on the environment, leading to more informed and responsible outcomes. Secondly, develop guidelines for judges to follow when adjudicating cases with environmental implications. These guidelines can help standardize how environmental issues are addressed within the existing legal framework, promoting consistencies in judicial outcomes. Additionally, courts and tribunals should be empowered to issue advisory opinions on the interpretation of international treaties, providing essential guidance on compliance matters to clarify states' obligations and reduce uncertainty or inconsistency in judicial interpretation. These authoritative interpretations can enhance legal certainty and promote adherence to international commitments. Moreover, establishing forums for judges from various jurisdictions to exchange experience related to international law interpretation is vital. Such forums will facilitate the sharing of best practices, leading to greater consistency in judicial decision across borders. This interaction not only fosters mutual understanding among judges but also contribute to a more unified approach in addressing complex international legal issues, ultimately enhancing the effectiveness of global governance in areas such as climate change and environmental protection. In a nutshell, the complexities of global climate agreements are significantly influenced by the differing legal frameworks of monism and dualism. Monist system automatically incorporate international law into domestic legislation, promoting compliance but potentially leading to legal tension when national laws conflict with international obligations. Conversely, dualist system require explicit legislative action to implement international treaties, which can result in delays and fragmented legal frameworks, complicating timely response to urgent issues like climate change. Ultimately, this theoretical distinction reveals the challenges nations face in harmonizing their domestic laws with international commitments, particularly in the context of multilateral environmental agreements. That's all from me. Thanks for watching.